Federal-state relations. We have looked at each of the three arms of the federal government: the legislature, the executive, and the judiciary. And we have seen that each of the governments in the 6 states also have 3 arms. This explains, therefore, why we have a federal parliament and a Queensland parliament, a prime minister and a federal executive, and a premier and a Queensland executive, a federal court system and a state court system. The question now is, how do these 2 levels of government work together? The relationship between the federal and state governments is regulated by the Australian Constitution. Upon federation, each of the colonies became states and gave up certain powers and rights to the new federal government, and at the same time retained their individual identities and substantial legislative authority. It is a mistake to think of the federal government as being superior to or in charge of the various state governments. Rather, the state and federal governments work together to regulate Australia. The Australian Constitution sets out certain exclusive powers of the federal parliament. These are the powers that can only be exercised by the federal parliament. They relate to things such as defence, currency, and the territories. Consider defence. It is not possible for a state to raise military forces, and so we do not have a Queensland Army or a Queensland Navy. Rather, we have an Australian Army, an Australian Navy, and an Australian Air Force, because only the federal government has the legal authority to regulate defence. Similarly, the currency in Australia is consistent from state to state because the state governments do not have the legal authority to make laws about currency. Only the federal government has the power to make laws about currency. When the federal system was established in 1901, certain areas of authority were retained by the states. These are known as the residual powers of the states, and they include education, property, transport, crime, and health. The reason why the schooling systems are slightly different from state to state in Australia is because education is regulated by the state governments rather than by the federal government. The reason why the process of buying a house in Queensland is slightly different to the process of buying a house in New South Wales is because property law is regulated by the state governments and not the federal government. The reason why the road rules change slightly from state to state, or why certain things may be legal in one state or illegal in another state, is because transport and crime are regulated by the state governments rather than by the federal government. The Australian Constitution also contains a list of concurrent powers of the federal and state parliaments. These are areas of law which both levels of government are entitled to regulate, and they are listed in Section 51 of the Australian Constitution. The matters listed in Section 51 include things such as taxation, marriage, banking, insurance, and external relations. If Section 51 sets out a list of areas that can be regulated by both the federal and state governments, the question again arises: what happens if both governments try to regulate the same thing in different ways? If the federal parliament has not actually legislated in relation to any of the matters listed in Section 51, then clearly that matter remains within the regulatory authority of the states. But if the state parliament has made a law in relation to one of these matters, and the federal parliament makes a law in relation to the same matter, then Section 109 of the Australian Constitution clearly states that the latter shall prevail and the former shall, to the extent of the inconsistency, be invalid. In other words, the federal law will override the state law to the extent of the inconsistency. The federal government has used Section 109 to override Tasmanian laws in order to protect the Tasmanian wilderness. It has been used to allow federal anti-discrimination legislation to override Victorian laws that denied access to IVF to unmarried women. and it has been used to override Queensland laws that denied land ownership rights to Indigenous Australians. Sometimes the states cooperate in the process of the federal government taking over a new area of law. So, for example, the states generally cooperated when a few years ago the federal government assumed responsibility for the regulation of corporations. At other times, the states resist the federal government taking over regulation and control of a certain area, and the matter will only be settled by litigation in the High Court of Australia. Since 1901, there has been a gradual shift in power from the states to the federal government, as the federal government has assumed more and more responsibility for the regulation of various aspects of Australian life. And so we have seen that the relationship between the federal and state governments is regulated by the terms of the Australian Constitution. These terms can, however, be changed. The Constitution itself contains a mechanism for amending the Constitution. A proposed amendment to the Constitution must be passed by an absolute majority of both Houses of Parliament and be put to the Australian voters in the form of a referendum and be passed by a majority of the voters in a majority of the states. Of more than 40 attempts to amend the Constitution made since Federation, only 8 have been successful. The most recent effort to amend the Constitution was the referendum held to decide whether or not Australia should become a republic by replacing the Queen as head of state. This attempt to amend the Constitution was, as we know, unsuccessful.